with us. There we go. Okay, can we hand over to Audrey, Kieran?
Yeah.
We can, thank you.
Kieran, can you see the slide, the front slide?
Yeah.
Lovely. Okay. So, hello everybody, and thank you very much for having me again to speak about the For Women Scotland case and the implications for women's charities. Can you see the second slide? Yep.
Yes, we can.
Lovely. So it's all working well. Right. So first of all, an introduction to me. I was a practicing discrimination solicitor until last November when I retired. I'd actually qualified in 1990, which is probably before some of you were born, as I'm now quite mature in my years. Since the mid-1990s, I've mostly worked in and run advice charities, and I led the campaign to set up Suffolk Law Centre in 2018, which I ran until my retirement. I write and train in all aspects of equality law and related issues. Though it shouldn't make a huge amount of difference today, I'm partially deaf, which just means that I do lip read if anybody does end up speaking on the screen. Thank you. So the ethos of this talk, so like everybody else, I've got personal views with regard to equality in practice, but where I state my views here, it's as a mainstream equality lawyer. And clearly where there are contested issues, there may be alternative views. I need to stress this is a legal talk, not a political talk. So I'm trying to cover all of the issues, but obviously from a very legal basis. The objectives of the training. Okay, so basically what I want to try and do by the end of the 2-hour period is to provide to you as women's charity leaders and staff an overview of the recent For Women Scotland case, and then in detail the Supreme Court judgment, and then give you some legal guidance how it will affect your service provision, both as employers and as charities. And you'll see that the Equality Act may affect your organisation in a multiple number of ways. Right. As with a number of things in the sort of sex gender area, terminology can be quite political. I'm very deliberately going to take the terminology I use from the For Women Scotland judgment. It's actually set out in paragraph 6. And you'll see, therefore, a person who is a biological man is someone who was born, who was at the birth of the male sex, but who has the protected characteristic of gender reassignment is described as a trans woman. I'll say that again. So a person who is a biological man, i.e. was at their birth of the male sex, but has the protected characteristic of gender reassignment is described as a trans woman. Similarly, a person who is a biological woman who was at birth of the female sex, but has the protected characteristic of gender reassignment is described as trans man. Trans men and trans women who've obtained a gender recognition certificate, which we'll call in these slides a GRC under the Gender Recognition Act 2004, are known as trans women with a GRC and trans men with a GRC respectively, and their gender resulting from the gender recognition certificate as their acquired gender or acquired sex. Biological sex is used to describe the sex of a person at birth, and certificated sex is used to describe the sex attained by the acquisition of gender recognition certificate. I'm sorry, it's quite convoluted, but it's going to be quite important as we go through that you understand the terminology that the Supreme Court used. Right, so my understanding of your organisations. So most of your organisations are charities. Most employ staff using the exception for occupational requirement, the Schedule 9(1) exception. Some services are for biological women only already. Some you're planning now to be so, but some want to retain services for trans women as well as for biological women. And some want women to be accompanied by young male children. hopefully I've got most of your organisations. There may be a few non-charities who are CICs or similar, but that shouldn't make any great difference. So the agenda for today. So initially, I'm going to make some brief comments about the Equality Act. I'm going to introduce you some legal jargon which you need to understand in order for me to explain the For Women Scotland case, then go through the case, then suggest some implications for your organisations and some proposals for what actions to consider, and then we'll take questions at the end. Okay? I should be able to get through it about an hour and a half with about half an hour for questions, all being well. Right, so the philosophy behind the equality law. So the first thing you need to understand is that the Equality Act applies to everybody. It's universal. Everybody has several protected characteristics, such as sex and a race and an age. And obviously others may apply as well. But the main thing is that the Equality Act isn't just for some people who are vulnerable or particularly disadvantaged or whatever the thoughts are, it applies to everybody. The second most important thing is that there is parity of esteem, which means that there is no one protected characteristic that's more important than another. There's no hierarchy of rights. That leads on to the third thing, which means on occasions, when we're looking at particularly finite resources, you know, access to a particular organization or some money's being spent on a particular activity or whatever that may end up in an equality thing, conflicts can happen. Conflicts are a normal part of equality law. And in practice, they can and do happen. And I'll explain what happens when you're addressing conflicts in due course. The next thing is that context, by which I mean in what circumstances of life the particular interaction is happening, where the decision's being made, those sorts of things. So whether it's part of a service provision, whether it's part of work, etc. And the actual evidence are key. And the final thing, and the one that a lot of people don't really get, is that not all discrimination is unlawful. We're not just talking about exceptions, though exceptions are important, and I'll explain why, to prevent greater discrimination. But some aspects of life, the Equality Act doesn't cover at all, or there is no specific requirements under the Equality Act. And in those circumstances, essentially, even if it's discrimination, it might still be lawful. So in practice, this idea that all discrimination is bad or unlawful or whatever, actually some discrimination is good. For example, I think most people would agree that disability-related reasonable adjustments, which theoretically are a form of discrimination, positive discrimination towards disabled people, were a good thing. So just as a philosophy, just understand that not all discrimination is unlawful. Sometimes it's used for the particular context because it actually reduces the incidence of wider discrimination. Right, so Equality Act. The Equality Act simply tells us what's prohibited. Prohibited means what's not allowed, what's required, so the things you have a duty to do, and those things which are allowed, you've got permission to do, you don't have to do them in certain situations to avoid unlawful discrimination and or harassment, etc. The other prohibited activities of the Equality Act. If you're ever in doubt, always check the Act. And I've given you a link on the slides because there are many sources of guidance that have errors of law. Unfortunately, this is an area where there's been a lot of misinformation. So, for example, AI is absolutely hopeless for the Equality Act because essentially there's an awful lot of rubbish on the internet that it draws from. So in practice, go to the original Act of Parliament. Right, so the first key term you need to know is protected characteristics, PCs. Protected characteristics are essentially just special attributes in the Equality Act, which were historically recognised as being the reason for widespread unjustifiable discrimination and harassment based on stereotyping and prejudice. We've had Discrimination Act since 1965, when we had the first Race Act. We then had sex and disability and so on, right through to the Equality Act 2010, which brought a lot of acts together, acts of parliament and statutory instruments together, and essentially created a general framework with a lot of exceptions. These are the protected characteristics. We've got age, gender reassignment, disability, marriage and civil partnership, pregnancy and maternity, race, religion and belief, sex and sexual orientation. In a normal introduction to equality law, I go into all of those, but this is not a normal introduction. So we'll skip over those and assume you know them, but they've all got definitions within the Equality Act. I will deal with a couple of them as we need to for the For Women in Scotland case. These are the types of prohibited conduct. Essentially, we've got direct discrimination, including associative and perceived, and I will explain those just because they're quite useful to understand the jargon on. We've got indirect discrimination, harassment, including sexual harassment, discrimination arising from disability, failure to make reasonable adjustments, that's a disability reasonable adjustments. Victimisation, we've got pregnancy and maternity discrimination. I tend to look at those separately because the prohibitions are very different to the other ones. Breach of the public sector equality duty, instructing, causing or inducing contraventions. There's a few criminal offences, mostly relating to guide dogs and taxis, and the breach of the equal pay provisions. Obviously, again, I'm not going to have time to go through those, but it's just useful to have them identified. So the next key term I'm going to explain to you is something called a comparator, because actually it's one thing that a lot of people don't learn about, and it's a really fundamental issue in equality law. A comparator is a tool used in equality law to compare the treatment of the claimant to another real or hypothetical or made-up person who should be in the same or not materially different circumstances, but doesn't have the protected characteristic of the claimant that's the subject of the dispute. So, for example, a man doing the same job as a woman. And one of the things that's quite important to remember is that all of the other facets of the comparator need to be identical, including all of the other protected characteristics, except for the one that is in question. So, for example, if the issue is around sex discrimination, then the real or hypothetical person generally needs to have all of the other protected characteristics of the claimant except for their sex. The next key term is provision, criteria or practice, a PCP, because that's the other major term that's used again and again in the Equality Act. A PCP is a rule, a process, the way we do stuff in our organisation. So it could be something in a policy, but it might just be a procedure, like client appointments are held upstairs, or only the directors get a car parking space, or all staff must be available to work on Sundays if needed. All of those things might be the PCP, the rule or process, and it's really important in terms of indirect discrimination or discrimination arising from disability, etc. And may address that later. Right. Again, I'm going to deal with associative discrimination. Associative discrimination is when you're discriminated against or harassed because either of someone that the claimant knew or someone they're associated has a particular protected characteristic. So essentially the decision maker decides that the carer for a disabled child is not going to be given a job because it's feared that they might have too many disability related absences. The discrimination is associated with the disability, so the carer would be able to bring associative disability discrimination claim, even though the carer wasn't themselves disabled. And perceived discrimination is when you're discriminated against or harassed because it's believed you have a certain protected characteristic. So, for example, refusing to employ somebody with an Arabic name because you wrongly think they're Muslim. The discrimination is based on a perception regarding the claimant's religion. So again, perceived discrimination. These might all seem slightly out of context, but you'll believe me, by the time you get to the end, you'll understand why I'm explaining what they are. Right, so the context in which the Equality Act applies. So the first one is services, facilities, and public functions. I'm saying it first, it's not necessarily the most important for you, but actually, as charities that work in the women's sector, there's a good chance that you are providing services, facilities, and public functions. You'll find the relevant important law in Part 3, Section 29. The second one that you might obviously think about would be work, which is in Part 5, so your employees, and it's slightly broader than employees, but doesn't include volunteers generally, though some volunteers might come into it. And there's a discussion in equality law at the moment about trustees, but again, it's not very clear at the moment. But on the whole, generally speaking, we would argue that all volunteers at the moment aren't covered. We've also got premises, education, and transport, which I'm not going to go into today. But the other one that some of you will be membership associations. And that obviously then those that have got a minimum of 25 members and some kind of rule system are governed under the Equality Act under Part 7. And that's set out in a definition in Section 107.2, if you want to have a look. So, as I say, charities come within the ambit of the Equality Act as service providers, employers, and sometimes membership associations. And as I say, so would CICs. Right. Okay. Exceptions. The starting point is really back to this universality principle, is no discrimination against any protected characteristic. But obviously that's not the end point as your women's organisations to say to you, you can't actually provide services only to women because the Equality Act would be very problematic, but that's not where it stops. But the starting point is no discrimination against any protected characteristic. However, in particular situation, just saying all discrimination is unlawful would itself cause consequential discrimination or other problems. It is actually recognised in equality law that in some circumstances, some discrimination is and should be lawful. And actually, a really useful case to look at, if you're ever interested in the idea of how and why we do have specialist services for a single protected characteristic, or one where all of the people who are involved share the same protected characteristics, is Crown against Core and Nor ex parte Ealing 2008, which is the Southall Back Sisters case, which predated the Equality Act, but the principles are exactly the same. Very well written, very useful to read as an example. And I'm just going to quote a part of the judgment. Lord Justice Moses, who made the judgment, quoted the chairman of the Equalities Review in the final report, Fairness and Freedom, to emphasise the legality of specialist services for particular protected characteristics. And he said, an equal society protects and promotes equality, real freedom and substantive opportunity to live in the ways that people value and would choose so that everyone can flourish. An equal society recognises people's different needs, situations and goals, and removes the barrier that limit what people can do and can be. And I think that's a really, really strong affirmation that there are contexts in which exceptions can be used and should be used. So, a few examples of exceptions actually within the Act. As I say, I've mentioned already Schedule 9, Part 1, Section 1, the occupational requirements. So, where you need a female to work in a single-sex charity. It might be that you want a Chinese actor for an all-Chinese production of Hamlet. It might be that you need a young black man to act as a role model for other young black men in an organization, a youth organization. We then have Schedule 3, Part 27, and I'm going to go into a lot more detail on these, which is the single-sex services. And then we have Schedule 3, 28, which is the trans-excluding services. We also have, though I haven't listed, Schedule 3, Part 26, which is the separate sex services, and I'll touch on that. But in practice, I'm going to focus more on single sex services than separate sex services, but the principles I will identify. Schedule 16.1, single characteristic associations, like a lesbian walking club, and then we've got Section 193, single protected characteristic focused charity, such as Southall Black Sisters, where all the members have to share the same protected characteristics. And I'm going to go into some more detail on those. Right, so let me just go firstly into the charities exception. So in practice, one of the ways that you can limit your services to a single protected characteristic, so or female only or whatever, is through Section 193. And Section 193.1 says a person doesn't contravene his act only by restricting the provision of benefits to persons who share a protected characteristic if, and there's two requirements here, A, the person acts in pursuit of a charitable instrument. What it's saying is essentially your charitable objects, which you would have, if you don't know what they are, they're what's held by the Charities Commission in your governance document, and they set out the purpose of your charity. So in practice, you have to act in accordance with the charitable instrument, and other provisions of the benefits is within subsection 2. So one, you've got to act in accordance with your charitable objects, and you also have to comply with subsection 2. Subsection 2 says the provision of benefits is within this subsection if it is a proportionate means of achieving a legitimate aim, or B, for the purpose of preventing or compensating for a disadvantage linked to the protected characteristic. Now let's explain what proportionate means of achieving a legitimate aim is. Proportionate means of achieving a legitimate aim means that you are seeking to undertake a purpose which is not unlawful. So it could be to provide a specialist service to a particular group who are disadvantaged. It could be because your organization was set up to provide a particular service which is still needed. It could be, and it could be multiples of these. It could be that there's a particular sex that needs the service a lot more. It could be the people who work for you have got specific expertise and you're focusing on that particular disadvantaged group. Proportionate means it's not too wide. It can't be so broadly drafted that it ends up being discriminatory. Generally speaking, providing that you set out very clearly why you have decided to do something, what your legitimate aim is, and the reasons for it, and the reasons for not doing something else. In my experience, that the courts are very, very reluctant to go back on that. So generally, this is a very broad brush statement, but generally speaking, if the courts hear a well-argued proportionate means of achieving a legitimate aim, then they're unlikely to go behind those. And the second one, which is an alternative, or B, it's for the purpose of preventing or compensating for a disadvantage linked to the protected characteristic. So obviously in the women's sector, it would be argued that they chose to limit their particular activity to a particular group because there is a specific disadvantage that they're seeking to prevent or compensate for. So it might be, in our area, there is a particularly high number of Eastern European women experiencing domestic violence. We've set up this charity for the purpose of preventing or compensating for that disadvantage. It's mentioned in our charitable objects, and thus it's a proportionate means of achieving a legitimate aim. We have looked at whether Eastern European males need the same service, but for the various reasons stated, we're not the organisation who can provide it. There are other organisations that they could go to. It may be that we haven't got the funding to provide a service for a particular group now, but we'll keep that in mind if more funds come available. Right, so now on to For Women Scotland. So, as you hear, it was unanimously allowed, 16th of April, and the case was For Women Scotland against the Scottish ministers. Right, let's start with some background legal myths, okay, in the dispute between sex and gender. Okay, so the first myth, and it's been a myth that's actually been around a lot of time, has been that on a self-identification basis, one could legally change sex. And this has never been true. There were consultations in the mid-2010s in England, which fizzled out. There was a Scottish Act to allow for the change of legal sex on a self-identification basis, but that was blocked by the UK government, and I don't need to go into reasons why, but essentially there's never been a situation where on a self-identification basis one could legally change sex. The second myth is that all trans people have gender recognition certificates. Actually, only about 9,000-ish, which is actually a small percentage of the number of people who have got gender, who are themselves, who come within the definition of gender reassignment within the Equality Act. The third myth is that having the protected characteristic of gender reassignment meant that you changed your sex legally. No, it didn't. It prohibited the unlawful discrimination or harassment because of or with regard to gender reassignment, which is not the same thing legally. And the fourth thing is that UK law doesn't recognise biological sex. There's a case called Corbett and Corbett in 1971 that says it does. And actually now, essentially, the Supreme Court have confirmed it through this litigation. So in practice, you just need to understand that in practice, when we're talking about the dispute coming to with regard to For Women Scotland, it wasn't about the vast majority of trans people. It was actually only about the number of trans people who had a gender recognition certificate. And the practical difficulty for a lot of service providers was that essentially there was some thinking that you couldn't ask people whether or not they got a gender recognition certificate. So in practice, it was very difficult to work out who did and who didn't, and to differentiate any service because of it. And essentially, that's one of the side issues of this litigation, but I think I needed to put those down in order to understand the principles. So let me just deal with the Gender Recognition Act. It happened in 2004. Section 9 says, Section 9.1 says, where a full gender recognition certificate is issued to a person, the person's gender becomes for all purposes the acquired gender, so that if the acquired gender is the male gender, the person's sex becomes that of a man. And if it's the female gender, the person's sex becomes that of a woman. But really importantly for this case, subsection 3 says subsection 1 is subject to provision made by this Act or any other enactment or any other subordinate legislation. So the general principles in subsection 1, that essentially a gender recognition certificate changes your sex, is subject to any other act, essentially either explicitly or by implication saying that the Gender Recognition Act doesn't apply. Now, the Gender Recognition Act was brought out for a whole bunch of reasons relating to pensions and to do with marriage, some of which were important at the time, some of which may still be important, issue of passports, driving licenses, etc. But the issue, whether the Gender Recognition Act had any effect on discrimination law had never been tested until this act. So it's quite important. The difficulty is that DEI in practice had been misrepresenting equality law, we know now, for some years. So in recent years, since the early to mid 2010s, the advice by some DEI practitioners has misrepresented equality law to organisations in the public-private sector. So there's been a lot of erroneous guidance provided by lobbyists on issues like who was entitled to use single-sex services. Well, as I say, the vast majority of trans people did not have a gender recognition certificate, but the guidance was suggesting that everybody who was identified as trans should be entitled to use single-sex services, which was incorrect. A second one was there was a suggestion that people could get ahead of the law as a positive thing. The difficulty with getting ahead of the law is that that ignores the risk of breaching rights of other people. Equality rights don't act in a vacuum. You have to think of them in some ways almost like an ecosystem, where if you make changes in one part, it can have effects on another part. And in this situation, clearly there's a conflict of rights between trans people and between those people who need single-sex services, for example. And de facto self-identification essentially took place, where service providers were treating all trans people as if they'd changed sex. So the background to the For Women's Scotland case. So the issue, basically the case concerned the legality of some Scottish ministers' guidance on the meaning of sex, woman and men in the Equality Act, which was actually cited in some guidance for another Act of Parliament. And actually, despite the public clamour, the issue was always, the case was and always is about the definition of sex, man and woman in the Equality Act. It's not actually about trans rights. So let's have a look at the definition of sex. Sex, section 11, sex, is a man or to a woman. Basically, reference to sex is to a man or to a woman. And the only other guidance in the Equality Act is in section 212, where they say man means a male of any age and woman means a female of any age. So, as I say, it was the original argument started as a result of a different Act of Parliament in Scotland. You need to understand that the Equality Act covers the whole of Scotland, England and Wales. So essentially, when we're talking about the Equality Act, we're talking about everything that happens in England, Scotland and Wales. The issue due to the Scottish Government passing the Gender Recognition on Public Boards Scotland Act 2018 and its associated statutory guidance, which aimed to increase the representation of women on public boards in Scotland. And the guidance that the Scottish Government issued defined women as including trans women on a self-identification basis. And a campaign group, a grassroots group called For Women's Scotland, they sued and they won a ruling that the guidance was unlawful. Following this ruling, the Scottish ministers issued new statutory guidance, and it was the new statutory guidance which became the subject of this Supreme Court appeal. So, the revised guidance stated that the definition of woman under the 2018 Act aligned with that in the 2010 Act, which defines women as a female of any age. And crucially, the new guidance also asserted that a male holding a gender recognition certificate, GRC, that was introduced by the Gender Recognition Act would be considered a woman for the purpose of the 2018 Act. So essentially they were saying that woman includes females and males who had a gender recognition certificate. So in 2022, the For Women's Scotland again challenged the lawfulness of this new statutory guidance, and their central argument was that the definition of woman in the Equality Act 2010 refers to biological sex. And conversely, the respondents, Scottish ministers, maintained that woman in the Equality Act should be interpreted as certificated sex. That's the term that the Supreme Court used, thus including transgender women with gender recognition certificates. So not all transgender women, just transgender women with the a percentage of the 9,000 or whatever it is that got a gender recognition certificate. And the Scottish courts found in favour of the Scottish ministers. It was then appealed to the Supreme Court and they were granted permission to appeal, which is the highest court in the United Kingdom. Right, so the role of the Supreme Court, just to reiterate, was to determine whether the Scottish minister's guidance was lawful and consistent with the Equality Act 2010. And to do that, they needed to clarify for the first time precisely what the words sex, woman and man meant into the Equality Act. And the parties, right, so the appellant was For Women's Scotland and the respondent was Scottish ministers. And we had some interveners. Basically, they're often civil society organisations who basically ask for leave, setting out what their arguments are on one side or the other. And we've got Amnesty International, who are an intervener supporting the Scottish government, the Equality and Human Rights Commissioner, intervener either neutral or partially Scottish, supporting the Scottish government. It's not entirely clear, but they took a slightly different view to the respondents and to Amnesty, but it was essentially their view was not the same as the appellants. Sex Matters, who are a charity who are interveners supporting For Women in Scotland, and then a group of 3 lesbian grassroots groups who formed a sort of consortium supporting the For Women in Scotland. One of the things worth knowing about, because again, it comes up on social media a lot, no trans groups applied to intervene. 2 individuals did who are trans identified, but leave wasn't given to their detailed applications. Now, no grounds were given, but it's likely that one of 2 possibilities. One, that they were not providing any legal argument, which was not being made by any other parties. So essentially, they weren't saying anything that the Supreme Court wouldn't hear from somebody else. But also, it's not normal practice of the Supreme Court to hear from individuals. One of the things you really do need to understand is by this stage, we're really looking at very detailed legal arguments. It's not about giving evidence generally. It's not about representation. This is about very detailed legal arguments. So unsurprising, it didn't come to any surprise that individuals weren't given leave. And we were surprised that no trans groups applied to intervene. Right, so the judgment is long, it's 88 pages, and it's meticulously detailed. Anybody who's a mainstream equality lawyer would say it's well written, but I have heard other people saying it's complicated. I'm not entirely sure why they think it's complicated, but that's for them. The point is that it sets out step by step, very, very detailed way how it's come to the decision it's making. The Supreme Court unanimously allowed the appeal. It delivered a decisive judgment that the terms man, woman and sex in the Equality Act 2010 unequivocally refer to biological sex. The Supreme Court considered it very important that the Equality Act 2010 is interpreted in a clear and consistent way, so that groups which share a protected characteristic can be identified by those who are essentially duty holders, those on whom the Act imposes obligations. So service providers, employers, etc., can be very clear what the duties that they are given the particular people in front of them, so that they can perform their obligations in a practical way. Right, so the court went back to the original legislation. It went through to the legislation and it looked at essentially what we call statutory interpretation. Essentially, the Equality Act is a consolidating and amending statute. So it retained a lot of the core definitions that were set out in previous legislation around discrimination. The court highlighted that the Sex Discrimination Act 1975, the precursor to the Equality Act, clearly intended man and woman to denote biological sex. There was an act called the Sex Discrimination Gender Reassignment Regulations 1999. It's a statutory instrument which amended the Sex Discrimination Act to also prohibit discrimination based on gender reassignment. But in doing so, they did not change or alter the fundamental meaning of man and woman, but rather they created a separate section that prohibited discrimination against those who would fall within a category called gender reassignment. And as I say, the Equality Act sort of retained those core definitions. So as you'll see in the Equality Act, sex is a completely separate characteristic to gender reassignment, and clearly note has been taken of that. The judgment emphasised that interpreting sex as certificated sex, which means somebody who is a part of the definition of gender reassignment, but actually has a gender recognition certificate, interpreting sex as including that category would create significant inconsistencies and practical difficulties within the Equality Act 2010. And they took a lot of notice of this. So, for instance, they said provisions relating to pregnancy and maternity are inherently linked to biological women. Similarly, the effective operation of single-sex spaces and services, communal accommodation, and women's participation in sport, by its wording, relies on a clear distinction based on biological sex. It's obvious when you actually read the text that they're looking at issues regarding bodies rather than certificates. And I think that's quite important, particularly as they did take note of the fact that to get a gender recognition as a certificate, one does not need to have any kind of bodily changes or take any kind of medications or anything. So essentially, when other people are perceiving people within single-sex spaces or within sport or communal accommodation, issues of the perception of other people in there becomes more important. And some of the cultural issues around the difference between males and females about privacy, difference in strength and size, and all of those sorts of factors is taken on board. And furthermore, and this is quite interesting because a lot of people who've been on social media haven't really taken this one on board, the court noted that a certificated sex interpretation would have the effect of inadvertently creating two tiers of protection within the transgender community. So you'd have greater rights for those with a gender recognition certificate and fewer rights for those without a gender recognition certificate. And that in itself would create huge problems, practical problems, for those who are required to uphold the Equality Act, because they also would have no way of knowing who a gender recognition held a gender recognition certificate due to privacy considerations, some of which are slightly overblown when you look at the law, but in practice, there is a lot of acceptance that you've got to be very careful about asking people for a gender recognition certificate. But it did mean that they didn't want to create this two-tier of protection within the transgender community. And the Supreme Court also noted and gave weight to the fact that its interpretation does not leave transgender individuals without protection under the Equality Act. And this is really important because this case essentially is a conflicts of rights situation. And in a conflict of rights, what you have to do is to look at the two competing rights and balance out, work out how to achieve all of the objectives that you want to achieve in the least discriminatory way possible. So whether the transgender individuals have got protection under the Equality Act is obviously a key factor. So protections under unlawful discrimination for transgender people, there's a number of ways that they are protected. Section 7, where the alleged discrimination is because of or related to protected characteristic of gender reassignment, that's protected. So basically gender reassignment discrimination is protected. There's also, which I haven't mentioned, there's a protection in section 16 about time off for treatment related to gender reassignment, but that's an additional benefit within the Equality Act. As section 11 also where the alleged discrimination is because of or related to grounds of their birth sex. So if there was sex discrimination against a trans man on the grounds of being female, they could bring a claim under Section 11. In addition, I mentioned previously about perceived discrimination on the grounds of sex. So if somebody perceives them to be a woman when they're biologically male or vice versa, one can bring a claim for perceived discrimination and also associative discrimination. So if they are discriminated against as part of a group, whether directly or indirectly, they could bring a claim on the grounds of sex, associative. So in practice, the court determined that there were these ways that transgender people had got and retained essentially their rights. So that's really how it happened. Oh, let me just go back. Right, so that's how it happened. So they looked at that, and that's why ultimately they decided that the definition in the Equality Act is biological sex, and thus for Women Scotland won the claim. And actually, as I understand it now, the original act that it related to, there is new statutory guidance which meets the correct definition. So what's the impact on your services? There's a lot of talk about the statutory code of practice, which is being consulted on at the moment. Basically, equality legislation allows for statutory codes of practice to put a bit more meat on the flesh, to provide some explanation for non-lawyers as to how Equality Act works. Now, in practice, there are a number of different codes of practice. The statutory code of practice on services, public functions and associations is the one that's subject to a lot of discussions. There is another one that's relevant to you called the Employment Code of Practice, which there is no plans to change at this stage. Technically, at the moment, this 2011 Code of Practice is technically in force, but it was long since out of date. It has been for years, and lawyers just don't rely on it particularly because it's really out of date. So generally, they just apply what's the law. So in this situation, the Supreme Court judgment is the law, and where it's inconsistent, Supreme Court judgment prevails. Now, the 2011 Code of Practice was being revised and consulted on over the last couple of years. It's actually been the subject of quite a lot of discussion for quite a few years because it was inconsistent with the law as it is rather than the law as some people would like it to have been for quite a few years. There was some clarification in the early 2020s about who was entitled to use single-sex services, but they're generally now revising and consulting on it. The new consultation is now closed. I understand they've had about 26,000 responses to the new consultation on the latest version, the one that they want to lay before Parliament. To be frank, there's going to be a lot of political shenanigans. Unfortunately, some of the MPs are making statements that suggest they don't really understand the law as it is. And I suspect that there may be some political concerns. And the upshot, which I think is probably not a particularly political statement, is the new code of practice may not be agreed by Parliament for some time. I think that's a very neutral statement. Whilst it's not in force, you can't ignore the judgment. You as a duty holder have to comply with the law. So you can't just say, I will wait for the new code of practice as a service provider. It doesn't wash legally. And your trustee's priority in terms of risk assessment means that you need to make sure that you're not the poor group who end up being litigated against. What again, a fairly neutral comment is that it's quite clear that both sides of this contested issue have been able to crowdfund quite a lot of money and therefore there are going to be situations in which they're going to be looking to make some test cases. And my strong advice to you is to think hard about being in a position where you're going to be picked on for not doing anything, or doing something that's inconsistent with the law as opposed to the code of practice. Right. So in the meantime, there was some interim guidance which was issued. It is not a code of practice. It can arguably, it's persuasive to court. It doesn't have to be taken into account. It's guidance. Clearly, some people don't like it. Actually, I've added since the last time I did this talk, I've added an additional link so it should say Ben Cooper, not Beck Cooper. Ben Cooper KC, who was one of the KCs acting for the successful parties. I think he was acting for Sex Matters, has done a very comprehensive article on this case and has looked at a number of suggestions by other lawyers and activists, and looked at whether or not they have any kind of merit. So there's some discussion about the fact that the judgment is inconsistent with European law, and he argues it isn't. Some people have suggested ways in which they might get around the legislation, and he's gone through and analysed why it won't work. So again, very worth looking up, though it is quite lengthy, again, and very, very meticulously argued. Right, so let's do some basic practical advice. The first thing is about you as charities and your legal duties. I've done a link to a blog which was published by a charities lawyer specialist called Pennington's Law on what is a woman, how charities may react to the recent Supreme Court ruling. And one of the things they say is that trustees, when trying to decide on the best use of their charitable assets, must, in all of their decision-making, act in good faith, balancing the relevant but not the irrelevant conditions, the public benefit requirement, the Equality Act and other applicable laws and Charity Commission guidance. So essentially what they're saying is that you've got to be very careful to be doing something which is consistent with the law, is consistent with your charitable objects, and you balance all of the relevant considerations. Anybody who's got a potential, you've got potential duty to, you have to balance those against each other, and also the public benefit requirement that all charities have. So the first thing I think you need to do is to work out precisely who your beneficiaries are going to be now. And this is, in my view, urgent. I don't think you can wait for statutory guidance either by the Equality Act, the EHRC or the Charities Commission. My suspicion is the Charities Commission will just say to you, you've got to comply with the Equality Act. It occurs to me that there's three possibilities that organisations that have any kind of single sex, oh no, sorry, in total, not in just single sex, three possibilities. First one is mixed sex. Absolutely no problem. If you provide services to everybody, men, women, however they identify, any other protected characteristics, no problem whatsoever. Obviously, providing that fits in with your charitable objects. And obviously, if you're going to go from a single protected characteristic to a mixed one, I'd change your charitable objects. But other than that, mixed sex, no problems. You can go single sex, either providing services to women or to men. Or the third alternative, which is the one I suspect I'm going to talk about most, is a mixture of completely separate services. Single sex, mixed sex, those for people with a protected characteristic of gender reassignment, trans women, trans men, and so on. So But the point about it is completely separate services. You can have one organisation, but the services have to be separated. So, admissions policies, who you allow in. You need to make a policy in accordance with the Equality Act. And as I say, starting point, no discrimination of anyone. And when you're deciding your policies, you have to remember all your legislation, all other legislation. So Charities Act, and any act relating to children, if you deal with children. But you have to remember the Equality Act, all the rest of it. Health and Safety Act as well. Safeguarding requirements, obviously, your organisation's charitable objects, what the expertise of your staff is, what your resources are, and what the needs in your community for services of your type for all potential service users. They're all relevant, and you need to think about them and document your thinking. And your equality monitoring can aid in considering met and unmet needs. And then you need to balance out all of the factors I talked about, considering all potential users and those who need a service, and then document your analysis. So I'm not telling you that you have to go from one thing to another, in the sense of, I'm not saying to you that you have to give up serving trans women if you want to continue serving trans women as well as biological women. You just need to think about all of the others, and you'd have to do that if you want to be a single sex service again. So you need to think about the needs of males, for example, the needs of transgender users, etc. And then you would look at your expertise, what other services in the community, what funding you've got, all of the other legislation, safeguarding, and you just document that and explain how you come to the decision that you come to. And I think that's really important. The cases that are successful for service users are the ones where they've really thought about what they're doing and why they're doing it, and what information have they taken into account. So, why in the Equality Act is a separate or single sex not a gender reassignment discrimination against a trans woman? And I think this is quite an important question to ask, so that you can understand the philosophy of the Equality Act. There's several reasons why. The first one is really fundamental. It's something called the because of test in section 11. Section 11 and section 11 is direct discrimination. With regard to is the same, which is the test in indirect discrimination. The key thing you need to understand is that trans women are not being excluded from a separate or single sex service because they're trans. They're being excluded because they're legally male. So in practice, any claim against you on the because of test, you're doing these things to exclude males. You're not doing this to exclude, assuming you're not excluding trans-identified females, but just excluding trans-identified males, then in practice you're doing it because they are male, not because they are trans. So the first reason why it wouldn't be gender recognition to operate as separate or single sex service against a trans woman is the because of test. The second reason is the use correctly of the exceptions in Schedule 3, 26 and 27 for a service user. Now, this is where I get into the whole single sex and separate sex services. Basically, your decision is not going to be on a case-by-case basis. The decision to exclude all males within section 26 and 27 has to be done when you set your admissions policy. It's a gateway condition, and you have to meet the conditions, which I will explain at the beginning, and then exclude all males from that service. It's also, if you correctly use it, a defence against sex discrimination by any biological male, not just trans-identified biological males. It's also, if you use the exceptions in Schedule 3, 26 and 27 correctly, it's also a defence to indirect gender assignment discrimination. if you can show that the appropriate use of exceptions is a proportionate means to achieve a legitimate aim. So if you meet the gateway conditions, it is a proportionate means to achieve a legitimate aim, and therefore it's a defence. It's also a defence to any indirect discrimination against by other biological males. Now, I know that's really complicated, but essentially what I'm saying to you is that if you apply a separate or single sex exception correctly through the gateway conditions, then it can never be either a direct gender reassignment discrimination or indirect gender reassignment discrimination. So, separate sex services exceptions. So, Schedule 3, Section 26. So, these are the gateway provisions which you would apply to your admissions policy for this service, which this service might be only one or two of 6 or 7 services that you provide, as long as you keep them separate. Schedule 3, Section 26 gateway provisions. Section 26(1), a person doesn't contravene Section 29 so far as relating to sex discrimination by providing separate services for persons of each sex if a joint service for persons of both sexes would be less effective, and B, the limited provision is a proportionate means of achieving a legitimate aim. And again, that terminology. So it's the least discriminatory way of achieving your particular aim, because you would have women self-excluding or men self-excluding if it was a mixed service. Okay. Schedule 3, Section 26(2) says a person doesn't contravene Section 29 so far as relating to sex discrimination by providing separate sex services differently for each person of each sex if a joint service for persons of both sexes would be less effective. Secondly, the extent to which the service is required by one sex makes it not practical to provide the service otherwise than a separate service provided differently for each sex. And the limited provision is a proportionate means of achieving a legitimate aim. So in practice, again, if it's much more practical, reasonably practical, to provide the service as a separate service, then again, you can use Schedule 3, Section 26(2). So those are separate sex exceptions, and I would invite you very much to read through them and to use the wording that fits closest to the situation you see yourself in to decide which of the exceptions you're using. Now, one of the things I need to make clear is that you don't actually have to explicitly use the exceptions by making the decision. If you forget to put the exceptions in your paper or whatever it is you're taking to your trustees, it's not a disaster. You don't have to publish them anywhere. Obviously, if it ever went to court, you'd have to show which of the exceptions you were relying on and what the evidence to support it was. And so obviously, if you've used terminology that meets the legislation, it's a lot easier to argue it, but you don't have to use that language if you don't want to. So in practice, again, just look very carefully at the separate sex services exception and work out which one meets the separate sex service that you're thinking you might do. Single sex service exceptions, that's in Schedule 327. Now, again, this is the gateway requirements. Essentially, if you can get them within the gateway requirements, then all people of the opposite sex are excluded. Section 27(1), a person doesn't contravene Section 29 so far as related to sex discrimination by providing a service only to persons of one sex if, firstly, any of the conditions in subparagraphs 2 to 7 are satisfied, and the limited provision is a proportionate means of achieving a legitimate aim. So basically, you've got to have one of the subparagraphs in 2 to 7 satisfied, and it's also got to be a proportionate means of achieving a legitimate aim. Schedule 327, the condition is only persons of that sex have need of the service. Well, I suspect that doesn't apply to, say, domestic violence or sexual violence, but it might do for cervical cancer or something like that. Subsection 3, the condition is that A, service is also provided jointly for persons of both sexes, and B, the service would be insufficiently effective were it only to be provided jointly. So you might have a joint service and a single sex service if that's what you're looking for. Subsection 4 is the condition is that a joint service for that person of both sexes would be less effective, and B, the extent to which the service is required by persons of each sex make it not reasonably practical to provide separate services. So, for example, if you've got 10 times the number of people that need the service, it may be that you provide the service for a single sex and another organisation locally would provide the other service. The fifth one, a condition is that the service is provided at a place which is or part of a hospital or another establishment for persons requiring special care, supervision and attention. That's really about hospitals and care homes. Subsection 6, the condition is that the service is provided for or is likely to be used by 2 or more persons at the same time, and the circumstances are such that a person of one sex might reasonably object to the presence of a person of the opposite sex. Now, that's one that you might choose to use because of trauma-informed services that your service group, the women who use your service might have a trauma-informed adverse response to the presence of a person of the opposite sex. So that's one that you might want to use. Subsection 7, the condition is that there is likely to be physical contact between a person to whom the service is provided and another person, and the person might object if A were not of the same sex as B. So mammograms, that sort of thing might be relevant, or a massage or something like that. Right. So those were single and separate and single sex services. There is also in subsection 28 an exception that allows for you to exclude all persons who've had any kind of gender assignment if the evidence supports a need to do it and it's proportionate means of achieving a legitimate aim. In the context we're talking about, it may be that there are some trans-identified females, trans men, who are so clearly passing that they might cause trauma to females as a result of their condition, and you may choose to exclude those people. Now, there's a bit of an argument about whether this is a gateway condition. I don't think it is. I think it's a case by case, section 28. And certainly I can't see using it that often, if only because I think most people, if you said to them, all of the staff are female, all of the service users are female, and they encountered somebody who looked quite masculine, may accept that they're just a masculine looking female. But there may be situations in which you might need to use section 28. It may be that you might use it, for example, to require no use of pronouns in correspondence, to avoid having pronouns in letters from a person who would want to use pronouns of the opposite sex, if your client group may have concerns about that. But this is the section that I think you would use not that often. Right. So, as I say, section 28, the section applies in those rare services where, due to particular needs of some users, objectively justified to exclude the very passing trans people, even of the correct birth sex as designated in the single sex policy. Right. Okay. What you can't do legally now, you couldn't do it ever because it's what the law was, but what you mustn't do now, you cannot have a single sex policy which includes a few people from the opposite sex because they have a trans identity, a trans inclusive service. You just can't do that. The consequences are unlawful. Essentially, you could get a civil claim against you by a direct sex discrimination claim against you by men who don't have a trans identity. Potentially also get an indirect sex and possibly religion and belief discrimination against you, against women who need a single sex service. And what I'm saying to you is that you're running charities or CACs, you do not want to breach your duties as trustees, nor invalidate any kind of public occupiers or employers' liability insurance that you may have by undertaking something which is unlawful. So this is my basic advice. Obviously, you might want to seek advice from specific lawyers, but tread very cautiously if you're going to run a single service which you're hoping to make female and trans inclusive, so including trans identified males or trans women. And generally speaking, case-by-case approaches for policies are not lawful. Therefore, it's policy by policy. What I said was a gateway, your admission policy, it then applies to everybody. And this approach is endorsed in a case by the Supreme Court, in a case called referenced by the Attorney General for Northern Ireland, Abortion Services, Safe Access Zones. And they said, questions of proportionality, particularly when they concern the compatibility of a rule or policy with convention rights, are often decided as a matter of general principle rather than an evaluation of the circumstances of each individual case. So basically what they're saying is it would be very difficult to determine on a case-by-case basis, an individual client-by-client basis, who you're going to admit. Issues around these sorts of things are done on a gateway policy by policy basis. So you set your admissions policy and then generally comply with it. What you might well be asking me is, isn't the obvious thing then just apply mixed sex services? Just assuming that we just provide mixed sex services for everything and then no forward discrimination. It's not as simple as that. Not providing a single sex service might be indirect discrimination against people who need single sex services. So assuming that your policy, your PCP, is a mixed sex service, if there's any evidence that a claimant, even if it's just a small group, are caused a particular disadvantage due to their protected characteristic, whether it's sex, race, religion, or belief, then legally it could be indirect discrimination. So, for example, if you've got a community in your of Muslim women who would self-exclude if you didn't have a single sex service, then that could be indirect discrimination against them on the grounds of their sex and on the grounds of their religion or belief. And you would look at those two issues separately, but in practice, given the Supreme Court case, you'd need to take that risk seriously. The burden is on the policymaker to show your policy of only having mixed sex services as a proportionate means to achieve a legitimate aim. And the existence of the single or separate sex service exceptions in the Equality Act is actually good evidence that Parliament saw a strong need and proportionality to use it, and there's strong evidence otherwise. So it reinforces the idea that organisations like yours might well need single sex services. They might need mixed sex services as well, but just taking a one size fits all is not the easy answer. So, steps to be taken by charities who wish to continue to serve trans women. Right, so first of all, charitable objects. Your charitable objects in your governance document. It's not an Equality Act point, and I'm not a charity lawyer. There's no definition of man or woman in the Charities Act, but I suspect they will take a similar line regarding the interpretation that the Supreme Court took to the Equality Act because of the wording of paragraph 156 for Women Scotland. And I'll explain it if somebody wants me to explain it, but just trust me on it. Essentially, they've said that this is how we're interpreting the Gender Recognition Act, subsection 1 and subsection 3. And they don't say it only applies to the Equality Act. They say it in broad statutory interpretation terms, and therefore it's likely that it also will apply to the Charities Act. The second advice I've got is split your services completely. That means premises, timing, staffing, submission processes, etc., all need to be considered. You need to think about your employment contracts and job adverts. The ruling affects the Schedule 9.1 Equality Act occupational requirements. Obviously, if you're running a trans service, you could have an occupation requirement for a trans person to run that service. You have to think about how you would separate them out from ensuring that they don't then come into contact with any of the women in the single sex service. Toilets and in terms of services, and toilets in terms of workplaces. You need to, with regard to service users, essentially you need to ensure that your toilet use is essentially consistent with the needs of your users. There's no statutory requirement to provide single-sex toilets to service users, but obviously you've got to avoid the potential for indirect discrimination. But also, you've separated out your services. So again, you might want to think about ensuring that trans users who use it on days when they're entitled to use the service have got adequate facilities. So look at all of your service users, disabled, male, female, trans identified, whatever, and just provide a reasonable number of services, ensuring that you ensure single-sex services, the single-sex toilets and washrooms for women, females, as well as any kind of mixed service as well. You just got to look at these sort of cubicles that are literally just cubicles opening into common washrooms, that sort of thing. Just be a bit careful, and you might want to think about repurposing them or thinking about who can use such facilities. Obviously, if you've got any kind of enclosed rooms with enclosed sinks, then you might want to think about making them available to any person, as long as it's a single user. Workplaces are different, and so obviously if your staff can use services, toilets and workplaces as open service users, you have to comply with the legislation. Regulation 20 of the Workplace Health, Safety and Welfare Regulations are required. You've got to oblige to provide single-sex toilets unless you, again, have conveniences or a separate room, the door of which is capable of being secured from inside. And by that we mean enclosed sink within the room, not essentially a cubicle situation. There's actually an exception with regard to discrimination in the Equality Act that identifies that it's not discrimination against anybody else to comply with this workplace regulations. And it's quite obvious that it's going to use the same terminology of man and woman as the Equality Act did, for the same reasons as I mentioned for the Charities Act. So, as I say, obligation to provide single-sex services and compulsory to provide sufficient single-sex changing and washing room facilities where they're needed. not compulsory for service users that are open to the public to provide on a single-sex basis or as single-sex facilities such as toilets. Again, they can be single-sex if it's proportionate means of achieving a legitimate aim. They can also be indirect discrimination against women if the only provision is mixed sex. That means they can't go to the toilet. Similarly, it could be indirect gender reassignment discrimination if you've got people with gender reassignment in your facility and the only provision they've got is makes them uncomfortable. Steps to take by organisations, positive action measures. You might do these occasionally. While there's no legal obligation to do positive action measures, when they're undertaken, they need to be undertaken lawfully, which means you do, again, need to be consistent with the Equality Act if you're targeting a particular underrepresented group correctly. And obviously, you need to do it in a proportionate way as well. So occasionally, you might use positive action measures and just make sure that you comply with the Women's Scotland provisions. All organisations, you need to review your equal opportunities policy, E&D policy, and policies in which sex and gender are referenced. They need to be reviewed in the light of the decision to make sure they comply. And when you're making policy, again, I keep stressing this, say whether you're using or choosing not to use single or separate sex services or other exceptions. Whilst you're not obligated to do so, if there are competing rights, it's very helpful to explain why you're deciding to do it and what the proportionate means to achieve a legitimate aim are. Membership associations, the starting point is no discrimination. There is an exception for membership associations, which are at least 25 members and have a rule book that allows you to do a single PC. That's an exception. What you can't do is have a situation where you've got more than one protected characteristic if all of the membership don't share that characteristic. So you can have females and you can have Asians, or you can have Asian females in a single PC association. What you can't have is women and Asians, including Asian males, because that's two separate protected characteristics, some of which some people have, and the other person has. In practice, the organisations that are currently trans inclusive will have to change their membership to ensure they're single associations. They can't have a mixture, for example, of some females and some trans-identified males, i.e. trans women, in the same club. There are ways that you, for instance, set up two separate clubs and then do collaborative activity, but you can't set up a single membership association that consists of two different protected characteristics. And that's and it goes on to say that this is the exception, essentially, that you can limit it to a single protected characteristic to benefits, facilities or services, or similarly guests, if they share that association. So these, again, is part of the exceptions, but it's a single association benefit. Trans men, starting point is that they're female, so they're normally allowed in women-only services, whether or not they've got a gender recognition service. And again, I'm just reinforcing that some trans men could be so medically modified that they pass, and you'll have to decide whether you want to include or exclude trans men. You can use the exception in Schedule 328. It's an untested argument around whether you determine this case by case or a gateway policy. Right, really difficult issue this. Women bring in their small male children. Does this mean that the use of the exception is no longer valid? First of all, the issue is not tested. It's been suggested by various barristers I know that possibly the odd child as a modest exception, which is unlikely to undermine the general aims, could be permissible. And there is a European court case called Gerhard Fuchs and Land Hessen, which essentially said that. So essentially, you might say, as a modest exception, we allow for small children in order to reinforce the aims that we don't want to deter women from coming to our service. Obviously untested, but that's the suggestion. The second way is that you could have a practice not to enforce normal admission rules where males are under a particular age. Again, you could try it, and it's untested. So, but certainly there has been some suggestion on social media that women bringing in their small male children is equivalent to adult trans women being allowed in. And I think that that's not really the case. I think it would be very difficult to argue that the general aims of the single sex service would be met by allowing some trans women in the way that you could argue it for small male children who are clearly small, not dangerous, and obviously if you weren't allowing small male children in, it would preclude women from using your service at all. So, key messages at the end: operate your charity in accordance with your charitable objects or get them changed. The starting point in equality law is no discrimination against anyone. So the starting point is fully mixed sex. But there are some legal exceptions that allow for single or separate sex services, but you can't provide a service for women plus trans women. It's not lawful. You can also create services for single protected characteristic. So you can create a separate service for those who come within the protected character of gender reassignment and exclude other people. Again, you can't mix it with others. You can create a range of separate services if your charitable objects and each of the services where you're using Equality Act exceptions allow for them with different admissions criteria. So in practice, you could divide up your services in a way that kept a number of different services separate. There is a possibility that not providing a single sex service or a separate sex service might be unlawful discrimination. Don't forget, unlawful indirect discrimination. Don't forget that. Also, don't forget that if a group such as trans women, you've got some evidence that they've got victims, actually not just even trans women, any males, if you've got some evidence that there is some need for your services, then at the very least document where they're going to get services from and why it's reasonable for you not to provide those services. You know, it may be that your funding doesn't allow it. It may be that your skill set isn't there. It may be that other people do the service better than you and you direct them to it, that sort of thing. But what you don't do is you can't just forget them. In practice, you've got to think about why you don't serve them and why it's reasonable not to. And don't forget equality law regarding your workforce, regarding toilets, occupational requirements, etc., and make them consistent with the way that Force Women Scotland works. Right, and now it's time for questions, and I'm exactly on time.
Excellent. Thank you so much, Audrey, for sticking to time and going through all that quite complicated legal speak in a way that I hope was accessible to us all. So if there are any questions, could you put them in the Q&A function, please? And one of my colleagues will read them out.
Yeah, just before I do that, Audrey, could you just stop sharing your screen? So,
Will do.
thanks.
Is that done now?
Yeah, that's done. Thank you. Okay, so there's a lot of information in there. A lot of the questions are
Clarification.
yeah, clarifications. So okay, I'll pick one. So okay, if a charity changes from single sex to mixed sex, do they need to stop calling themselves a women's charity? And are they no longer allowed to hire women who work there, even if you're offering a trauma-informed service?
Okay. Ultimately, I don't think the name of an organisation is legally important, but obviously the key thing for a charity is your charitable objects. And I think that the Charities Commission might, just as a matter of practice for the public benefit, might be concerned that the public would be confused if any town women's service is a mixed service only. And so when you put in your charitable, you apply to the Charity Commission to either become a charity or you change your objects. I think if you kept your name, the Charities Commission might object, but I'm not sure that it's legally problematic. The important thing would be your admissions policy. So if you're a mixed sex service, you can't refuse to accept any male. You can't say we're a women and trans-identified male service, and so we're going to exclude other males. It would have to be completely mixed sex. So I think it's what your admission service is rather than what your name is. But I think that the Charities Commission or your funders might balk at you not changing your name if you became a mixed sex service.
Okay, and how would an organisation practically check if every single user is female?
In practice, I would say that a signed declaration is probably the most practical way of doing it. So literally, you would get them to sign an application form or something that makes a declaration that they're of what their sex is. I don't think it's necessary. I think it's very unlikely that many people will lie on an application. I think if you were suspicious that they were lying on a application to use your service, then in practice you might want to ask them for some evidence of their biological sex. But I think that's practically quite complicated, simply because I think that one can change one's birth certificate and passport and those sorts of things. Ultimately, it may come down to visual appearance. I think it's less problematic for women's services because in practice, and this is a generalization, a horrible generalization, I think trans-identified women, i.e. trans men, in my experience, seem to pass a lot more than trans-identified males, i.e. trans women. A lot of trans women physically still retain features of looking like males. Most trans people don't lie. And so, you know, in practice, I think they're no more likely to lie than the rest of the population. Ultimately, I would say just get them to sign a statutory declaration. Sorry, that sounds legal. Literally, if you had an application form to accept your services, you would have on the form something like, I declare that I am biologically female or male or whatever the particular criteria is. And you make it quite clear that if any of the information on the form is incorrect, then you have the right to terminate their use of the service. I think that's probably what I would do as a proportionate thing. It may be that you might want to make other inquiries. I mean, it will vary from organisation to organisation in safeguarding, because I could see a situation in some situations where you would want to know more information about somebody who's coming into your service than just their biological sex. So, for instance, whether they've got previous convictions and stuff like that. I don't know. I mean, it's one of those things where each organisation might be different, but generally speaking, a signed declaration with an indication that if they lie and you find out they've lied, you'll stop giving them a service is probably sufficient. Okay.
Yeah, thanks, Audrey. And then another clarification. So just so we're clear, someone's asking, so it's mixed or separate services, and a trans woman can't be included in any female only setting? That's
correct.
Yeah, okay.
But yeah, I mean, you know, they can be included in a mixed sex service. They can be included in a trans woman could be included in a male service if they wanted to use a male service. So I've just got to be a bit careful about saying they can't use any single sex service. They can't use a women's single sex service. Yeah.
Okay. And then about the children issue. So someone's saying a service seeing women, female and male children seeing female and male children can no longer be in the same building as a different service only for legally recognised women.
Sorry, I don't understand the question.
I don't understand it either. Sorry. Okay, I'll move on. In terms of having a practice to enforce admission of males under a certain age, considering this is untested, what age would feel most appropriate? Would different ages like preteen or including teenagers under 18 have any differing implications, do you think? Or does it just need to be a consistent policy that's written down?
I would say you just need to come up with a policy which is a proportionate response to a legitimate aim. So, I mean, I can't speak for the organisation because I don't know what services they're providing, but you'd look at what are the practical implications of your particular service. So might this person end up in a communal changing room, for example, or might this person scare somebody who was traumatized by males? So I was thinking probably much more younger children, you know, much more in line with sort of age that you'd stop going into opposite age changing rooms in the swimming pool and that sort of thing. But also it might be something to do with the age that you can leave your children safely. If you were going to a let's say if you were going to a day service and you couldn't leave your children at home, and that means that you would have to not go to the day service, I could see a situation where you might say, you know, children of up to 12 or something come into our service and then they play in the garden while we do our communal session. Or do you see what I mean? A different service is going to have different ideas, but the main thing is having, I think that the courts would find a way of allowing a few male children in of a younger age if it allowed for women who would otherwise self-exclude to come into this service. And it's not a gotcha. I think they would find a way of accommodating it legally using that European case that I've mentioned. But you'd obviously have to depend on the particular service. I certainly don't think you'd be allowing in 16-year-old males into a single-sex service just because they happen to be the child of one of the participants, for example. Yeah, although that's the sort of thing I would be thinking about, but it's going to vary from organisation to organisation. Okay.
And do you think it's advisable to have a written policy in place if an organisation is a single-sex service operating in line with the Equality Act? Do they need to write something special, or is it enough that they've got the charitable objectives? And
no, I would say that they should have an indication of why is it a single-sex service, and just go through their thinking about why they think there should be a single-sex service, because there is a theoretical risk that any male could argue that it wasn't a proportionate means of achieving a legitimate aim to have a single-sex service. And so you'd look at what your skill set of your staff are, what you were funded to do, what you were set up to do, what other services are available, why you don't serve men, and it may be the needs of the particular users. It'll probably be stuff that you've already thought about and you haven't put on paper. I think it'd be a really good idea to have somewhere documented, and it doesn't need to be in any particular format. It just needs to be the thinking that you've used as an organisation to explain why you are using one of the single sex or the charitable exception. Yeah, so it's just basically putting down, you'd say, we were set up in the 80s to provide a specific service for women because there wasn't a service around. The particular profile of our organisation is to serve this particular group of people. All our staff are experts in this particular area. etc. And you just document it. And it's not compulsory, but it's a lot easier to show why you're doing it if anybody challenges it, if you've got that in your documentation, and your trustees have agreed that. So I would think it would be a very sensible step to take if you haven't done it already, if only because you understand that the starting point is no discrimination against anybody. Yeah, this is not a you know, the starting point of the Equality Act is one size fits all, but one size doesn't fit your sector terribly well. And that's why you've got exceptions. Okay.
Okay, great. Okay, we'll move on to another one. So you mentioned positive action only briefly. Please explain whether or how an organisation wishing to include trans women in a women-only service could use the positive action provisions to do so. If you don't think that's possible, where would the risk of a discrimination claim come from, and who would be the comparator?
Right, okay. Let me just see if I can find there's a section that Ben Cooper's written all about positive action. Let me just see if I can find it. It's single characteristic. Let's see if I can. Let me just see if I can. I might. The obvious answer is to read Ben Cooper's advice, because it goes into several paragraphs on positive action. There's some very, very complicated technical reasons why positive action wouldn't be allowed. Okay. Right, let me just have a look. Right, okay. Right, okay. The positive action, this is Ben Cooper's written, it's quite long and complicated. Positive action exceptions are not limited to sex and are a somewhat different analysis applied from those one considered above in relation to single-sex services. Section 158, which is the positive action section, makes general provision in favour of persons who share the same protected characteristic, where A, the duty bearer has a reasonable belief that such a person suffers a disadvantage connected to the characteristic, have particular needs that differ from those of people who do not share the characteristic or are unrepresented and underrepresented in a particular activity. So he sets out what positive action is there for. So you can basically do certain things. It allows certain exceptions, positive action, to the general prohibition on discrimination, to enable people who share a particular characteristic to be treated more favourably than those who don't. The decision of the Supreme Court in Forminium Scotland means that in applying these exceptions, the needs of women or men and those of people with protected characteristic have to be considered separately, and they can't be conflated. So thus, men who identify as women cannot benefit from positive action to meet the needs or interests of women, but can benefit from positive action in relation to trans people. In fact, since not having the characteristic of, so basically you can do positive action for all trans people. But the point is about it is that because you're using an exception to allow in women, you can't then overlay it with a positive action on top of that to allow for women and trans identified men as part of the same activity. It doesn't work, because essentially you're undermining the reason for the single-sex service. So in practice, you could create a separate service for trans people, and that could be a positive action thing. What you can't do is overlay it when you're already providing a service as part of another exception, because essentially you're undermining the exception as to why you exclude all males. Does that make sense? Okay, but as I say, if I've said, I did a link to Ben Cooper's advice. He's at Old Square. And so if somebody wants to look it up, there's another 3 or 4 paragraphs on explaining why positive action can't be used to make it trans inclusive. It just doesn't work legally. I know there's been some discussion about it. It's not, in my view, it's not a goer. And essentially you'd end up in a situation where the court would say, if you allow some males in, you have to allow all males in, basically, as a positive act. It just doesn't work otherwise. But anyway, other people might disagree with Ben and myself. That's going to be up to the court. But to be honest, I wouldn't be the organisation that sets my stall out on positive action working as a way of creating a trans inclusive service. I think if you did that, you would be the one that's being sued, because somebody will want to sue you to establish that principle. So, you know, it would take a very brave set of trustees to take that approach. But, you know, it's ultimately I can give advice. I you know, if people choose to use it, it's up to them. Yeah. And I don't mean that meanly. I'm just saying that, you know, in practice, I ran a charity. You're not going to want to be the charity that's sued. So you don't want to do something that looks legally problematic.
Okay, thanks, Audrey. We've got someone saying, so you said that women-only organisations can't also support trans women. Does this apply?
Oh, sorry, I didn't say that. I said that they could, but sorry. You can be a charity.
Sex service wouldn't be able to support trans
separate service. Yeah, separate service. Yeah, sorry.
Does this apply equally to all services? Which I don't think it does, because you've said
you can have separate services within your broader organisation, each with a different administration. As long as you're consistent with keeping women separate and your trans service or your mixed service or whatever it is separate. Yep.
Okay. Is it lawful for a local authority commissioner to commission a mixed sex service from us as a women's charity with women in charitable objects?
Okay, that comes back to the Southall Black Sisters case. So whoever's written that, I'd strongly advise them to read the Southall Black Sisters case. And if you think that, as with the Southall Black Sisters, that you can demonstrate that there is a need for a range of different services in your community and you want to be providing a specialist service only for women, then in practice, by all means, challenge. You have to do it by way of something called judicial review. You have to do it within 3 months and often less than of the decision being made. But certainly if I saw unmet need as a result of requiring only mixed services, I would think about a challenge against that policy, simply because, you know, it's fairly established law that, you know, groups like some Muslim women, some Orthodox Jewish women, women who've experienced trauma, various other things, have a need for specialist services, and it's quite well evidenced. So,
okay. And then someone right at the beginning asked a question about organisations that are dragging their feet, or, you know, they are still including trans women as women and what to do about it. And there's another question saying, there's an organisation in my city that's still including trans identified men as members.
right.
Trans women as members. It's also saying that you can only join as a member if you believe trans women are women. Are they acting lawfully?
No.
Yeah. Okay.
I mean,
the question is, what can you then do?
Yeah, I mean, the thing is about it is, as a solicitor, you have to look at what the law says, but also in practice, what's going to happen. Most of the organisations will get away with it, of not complying with the law. Some organisations won't. We don't know who's going to bring claims. What we do know is that there's legal aid available for unlawful discrimination. There's obviously the Good Law Project, who are supporting trans people for what they perceive as being unlawful situations. And J.K. Rowling's just set up a funding mechanism for women who want single-sex services to identify unlawful policies and potentially take legal action. We've got some very litigious civil society groups who are looking for test cases. And therefore, you know, in practice, if you choose to be, I'm trying to think of a neutral expression, assertively trans inclusive in a way that's inconsistent with the legislation, you are at risk of somebody suing you. And your trustees need to know that, because if you work outside the terms of the law, in practice, your trustees could theoretically be personally liable. Your insurance company need to be notified because it could negate your insurance. Now, these are all theoretical risks. I can't tell you any of these things are going to happen. You know, I think thousands of organisations will get away with it, but one of them won't. And it's really about whether you want to be the organisation that complies with the mainstream view of what the law is, or you're an outlier who risks it. And to be frank, the most important thing you need to understand as charities is that it's the trustees, not the staff members, who make these sorts of decisions, and not, if you know what I mean. So at the very least, if you know, I would be saying to you as responsible staff members, you need to get your trustees on board and really understand the legal implications of what you're seeking to do, because it's not fair on the trustees if they suddenly become exposed to legal action that they weren't aware of. Now, it may be the trustees decide it, but, you know, my view is, for what it's worth, you know, that you need to understand that the mainstream legal position is that if you want to provide a women's only service, it has to be women only and not include any trans women in that particular service.
Yeah, I mean, someone has said that they are actively working with the Good Law Project and that their advice is contradicting yours, and you know,
Yeah.
if you're prepared to do a test case, then you know, maybe this organisation is. But yeah, just be aware of the risks.
Yeah, and I think what you need to understand, and you know, people can disagree with me, is that having looked across the piece at all the lawyers, my position is the mainstream one, and the Good Law Projects isn't, and therefore you just have to have that one on board. And by all means, read, for example, Ben Cooper's advice. You know, read some of the stuff by other lawyers. The trouble with any of these activist legal projects, whether it's Christian Concern or the Good Law Project or J.K. Rowling's one, is they're all activists, and therefore they're looking for their particular position to be supported, but they've got no adverse consequences on them if it goes wrong. And so you just need to understand that, you know, in terms of politically, reputationally, financially, if you're going to take a legally unusual position, you need to understand how are you going to protect yourself with regard to all of those factors, because what you don't want to do is to be the, you know, I mean, certainly the Good Law Project's intention is to go to Europe, and they probably will need a test case. And, you know, the idea of being the test case on something like this would, as a charity manager, would fill me with horror, because it would be a massive distraction for 5 years from my core business. But I don't feel particularly strongly one way or the other. So, you know, in practice, that's just my view. Just get very, very good legal advice. And I would suggest, if you're going to get good legal advice, get good legal advice from somebody who is not an activist.
Okay, we've got 4 more minutes left.
Okay.
So just to say that we will be putting this online, and the slides will all go online, and we'll do a kind of FAQ kind of summary. But I'll just try and there is somebody who says, can they speak? So I will try and allow that to happen.
Okay. You might need to repeat what they say. I can hear you quite clearly, Kieran, but if I can't hear the other person, I'll just ask you.
Okay, allow to talk. Okay, Mariana?
I did put the question again. It was just for clarity. Can you hear me both?
Yeah.
Yes.
Yeah, so it was just, so where a service is offering, for example, therapy to female and male children, so that is one service, and they operate in the same building as a different, same organization, but a different service providing, I don't know, financial benefits support or housing support or advocacy. So it's the same organization, two different services. The latter is serving only women. Is this scenario, what you're saying, no longer feasible?
Okay, and they all come on the same day?
Mm-hmm.
Right. I mean, okay. I mean, it sounds to me like, why is it not a mixed, sorry, I don't really understand why, if you're just having individual therapy, it's not a mixed service. I don't get that it's not the equivalent of going to the doctors and you go into a room privately with the doctor. Have I got that wrong? Is it group therapy or?
No. So women's service, providing therapeutic support,
Yeah,
to boys and girls for the same type of violence, for the same experiences of violence, so the same area of VORG, because it recognizes that vulnerability transgresses sex or gender, then a different part of addressing that VORG impact might be support with housing. So we have the same building, two different services, but to two different types of service users. So what I'm trying to understand is, my understanding from what you've said is that is no longer feasible. That is a risk.
in practice, what I'm saying is that it may be that your type of service, where you're not talking about people who are traumatized by the presence of a male, but
yes, we are talking about potentially that, yeah.
Right. Sorry. The point about it is, if you're, I probably have to talk to you separately, because I'm really struggling to understand why it's not a mixed service. It sounds to me like a mixed service, but it may be that conceptually you got people. I'd have to work out where people were mingling between each other and where they were separate, if you see what I mean.
No, might share same toilets, might share same waiting area, but I think you've actually answered my question, that actually it's an area that needs, that sounds like there isn't a clear answer and needs maybe more.
I don't think it's a clear answer. I mean, by all means, if you want to get in touch with me separately, I can have a go at trying to sort of unpick it if it's not too much work. But in practice, I think the thing is about it is that I think it's more important in situations like domestic violence shelters, where the presence of any male would be problematic, or group therapy, where people wouldn't open up if it was the opposite sex, or if you're talking about situations where some bits of the service are in private rooms one-on-one, and you'd have, say, the same sex person there, but people can cope with mixed sex in the waiting rooms and stuff like that, then it's probably a mixed service anyway.
I need to get clarification, but thank you.
No, yeah, I mean, the thing is about it is that it may not be the big problem you think it is, if you see what I mean, in the sense that you might just decide to have, rather than a general six policy, have a situation where you just say, we will only, have a female therapist with a woman and a male therapist with a man, or whatever you decide to do, and just make sure that those comply with the rules.
I see that's armed me with some more useful questions for myself. So yeah, thank you.
Okay. Right, more questions or not?
Well, we've come to time. Yeah, so I would maybe suggest, if anyone has outstanding questions that they would like clarification on, then to email WRC, and we can collate them and kind of write something up and put it on the website. I think a lot of the questions that I've seen maybe are just a re-clarification of things, etc., because there's just been so much information.
Yeah, I appreciate that.
Yeah, I'll hand back to you now, Ray.
Okay, thanks. I don't think I can get my camera on. It looks like the host has turned it off. But anyway, I just wanted to say, of course, a massive thanks to you, Audrey,
You're welcome.
for going through that in great detail, and also to everybody that's come along. I hope it was useful. And as Kieran said, do send us any questions that you have, and we will do our best to cover that. Yeah, and take care, everyone. Look after yourselves, and hope to see you again at another event. And thank you so much, Audrey. Thank you.
No problem. It's lovely to talk to you all. Thanks.
Bye. Bye-bye.